This video has been prepared for general information purposes only. The information is not legal advice. Legal advice is dependent upon the specific facts and circumstances of each situation. The information contained in this video cannot replace the advice of a competent, licensed attorney. You should be sure to consult an attorney in your area to discuss your particular case.
Leaving an abusive relationship or seeking an order of protection can be dangerous. If you have not already talked to your local domestic violence advocate, we recommend that you do so. You can find your local domestic violence program by visiting scadvasa.org. That's SCCADVASA.org. Or by calling 803-256-2900. For help 24 hours a day, 7 days a week, you can contact the National Domestic Violence Hotline at 1-800-799-SAFE. That's 1-800-799-7233. The hotline will connect you with the program in your area.
I'm an attorney at South Carolina Legal Services. We at Legal Services would like to give you some basic information about orders of protection. We always recommend that you consult an attorney if you can afford one. A domestic violence victim advocate can also help you find other resources that may help you during this difficult time. Our colleague, Joy, will ask me some questions that you might have if you're interested in filing for an order of protection.
So what is an order of protection?
It's an order from a judge finding that you are abused and ordering that the abuser must stay away from you. To file for an order of protection, you must file a petition.
And what is a petition for an order of protection?
This is the form where you tell the court that you are asking for an order of protection and why you're asking for it. After you file the petition, you will have a hearing in front of the judge. The judge will listen to you and your witnesses and will decide if you qualify for an order of protection.
So can I apply for an order of protection?
You can apply for an order of protection if you've experienced abuse, and if the abuser is your spouse, ex-spouse, a boyfriend or girlfriend that you lived with, or boyfriend or girlfriend that you had a child with. Of course, you can always think about what's safe for you. Leaving a relationship can be a violent time. A domestic violence victim advocate can help you think through these issues and develop a safety plan.
So when should I apply?
As soon as possible. If you wait too long, it may appear to the court that you do not really need the order of protection. The sooner you apply, the more likely you'll be able to get it.
How long does an order of protection last?
The order of protection will last between 6 months and a year. If there's a good reason, a judge can extend it. If you're granted an order of protection and you believe there is a good reason for the judge to extend it, you should contact your local domestic violence victim advocate at least 1 month before your order of protection expires.
Will the court give me custody or child support with this order of protection?
During the order of protection process, you can ask for other relief or things such as custody, child support, use of a home, use of a vehicle, or even a family pet. However, the judge does not have to order those extra items. In an order of protection hearing, the most important piece of information that you need to relay to the judge is about the abuse. If you do not convince the judge that you were abused, he or she will not order any of the other relief. It's important how you show that those things are related to safety.
What should I bring with me to court?
If someone saw or heard the abuse, ask them to come to court to testify. If you have records about your injuries or proof of the abuser's threats, bring those to court also. Records might include cell phone records, medical records, or anything else that might help prove that what you're telling the judge is true. The judge at the hearing might decide that you cannot use the proof you brought, but it's better to have it.
And what should I wear to court?
You should wear the type of clothes that you would wear to an interview. Wear conservative clothing and nothing that would seem too revealing.
What should I say when I go to court?
You should be honest and tell the court what happened. Do not start talking about child custody or child support or any other issues until after you've talked about the abuse. Try not to ramble. Tell the court about any injuries you had as a result of the abuse. You may want to practice what you're going to say so you feel more comfortable. Also, if you have a victim advocate in the courtroom with you, that might also help you feel more comfortable. So for example, the judge might say to you, why do you need an order of protection?
Well, I told the judge that I need custody because my husband is a jerk.
Why do you say he's a jerk?
Well, the whole reason I'm here today is because last Friday he got drunk again and we started arguing about bills. And then he picked up a lamp and swung it at me and hit me right here on the side of my head.
Those are the kind of details that the judge needs to hear to help him or her make the decision about the order of protection. If you just told the judge that your husband was a jerk and that's why you needed custody, that does not give the judge a lot of information to work with.
So how should I behave in court?
Don't roll your eyes, don't yell, don't interrupt the judge or anyone else who will talk, even if they're telling lies. Things that may be said in court that are going to upset you. Talk with your advocate about this before the hearing so that you're prepared. Don't chew gum or curse. Stand up when you speak to the judge, and refer to the judge as your honor.
Will he be at the hearing, my abuser?
The abuser will probably be there. He or she will have the opportunity to ask you questions about what you said. Be calm and answer honestly. It's important to show the judge that you are controlled and calm.
I am so scared of how he's going to act. What if he tries to hurt me when I'm there?
If you think that the abuser might be violent in court, contact the bailiff or the deputy at the courthouse. They may be able to take extra steps to keep you safe. They may be able to offer an escort to your car after the hearing if you need one. Some courthouses have conference rooms that you may use, or a waiting room, or another place that you can wait where the abuser is not there.
And what if I'm served with papers while I'm at this hearing?
If you're married to the abuser or you have children together, you may be served with legal papers that might include divorce or custody actions. It's important that you contact an attorney immediately after the hearing if you're served with papers. There are probably deadlines to receiving the papers.
And what's a mutual restraining order?
A mutual restraining order is an order that requires both you and the abuser to stay away from each other. A judge may ask you if you agree to a mutual restraining order. You should be very careful before you agree to one. In a mutual restraining order, it's not clear who was at fault. Both of you are equally ordered to stay away from each other. So it's possible that you could get in trouble if you violated part of a mutual restraining order. You can politely tell the judge that you do not want a mutual restraining order if you do not.
And what happens if my order of protection is denied?
There are several reasons that your order of protection may be denied. It does not mean that you were not abused. You may want to discuss other legal options with an attorney. You should also speak to your domestic violence victim advocate to help you create a safety plan to keep you safe.
And what if my abuser violates the order of protection by contacting me?
If you receive an order of protection and your abuser calls you, follows you, or harasses you, you should contact law enforcement. You should keep copies of your order of protection with you at all times. You may even want to give copies to neighbors, daycare workers, or at your child's school.
And what happens when my order of protection expires?
When the order of protection expires, so does everything else that the judge ordered. For example, if the judge ordered child support and custody, those are going to expire when the order of protection expires. So if you need child support and custody to continue, you should contact an attorney to help you file another court action before your order of protection expires.
So can my order of protection be extended?
Yes, it can be extended for what they call good cause. If you believe that you need your order of protection to be extended, contact your local victim advocate to help you at least a month before your order of protection expires. It will be up to the judge to decide whether you have good cause to continue your order of protection.
So what should I do after my order of protection has expired?
Consider talking with your victim advocate to help you make a plan to stay safe. Also consider meeting with an attorney to discuss your legal options.
Well, thank you so much for your time. I really appreciate it. I feel more informed now.
Thanks for coming in.
Thank you.